This case arose from legislation in the UK called the Street Offences Act 1959, which was intended to prevent prostitutes from seeking customers on the street. Freddie Shaw began publishing a booklet called The Ladies' Directory, which was basically a booklet of advertisements for prostitutes. He published about 10 successful editions, but was ultimately charged with, among other things, a common law criminal offence called conspiracy to corrupt public morals. Now, there was no legislated criminal offence which covered publication of this newsletter. The question was whether the court was justified in criminally punishing the conduct anyway on the basis of common law. Lord Simons, discussing the relationship between law and public morality, said, "The law must be related to the changing standards of life, not yielding to every shifting impulse of the popular will, but having regard to fundamental assessments of human values and the purposes of society." From this, Lord Simons concluded, and the majority agreed, that there is in that court a residual power where no statute has yet intervened to supersede the common law, to superintend those offences which are prejudicial to the public welfare. Such occasions will be rare, for Parliament has not been slow to legislate when attention has been sufficiently aroused. But gaps remain, and will always remain, since no one can foresee every way in which the wickedness of man may disrupt the order of society. Lord Reid, however, strongly disagreed, and his dissenting judgment over the years has come to be regarded as the proper expression of the law. He said that morality is contestable, and that laws about morality should be determined by parliaments, not by courts. He said, "Notoriously, there are wide differences of opinion today as to how far the law ought to punish immoral acts which are not done in the face of the public. Some think that the law already goes too far, some that it does not go far enough. Parliament is the proper place, and I am firmly of the opinion the only proper place to settle that. When there is sufficient support from public opinion, Parliament does not hesitate to intervene. Where Parliament fears to tread, it is not for the courts to rush in." From this case we learn that courts should hesitate to overreach the boundaries of their power. The courts should judge legal disputes and never political disputes.